1997, the claimant was designated. The claimant's designation was changed from messenger cleaner to senior craftsman on salary grade level 4, step 2, as technician electrical installation and maintenance department. The claimant on the claimant to the claimant stated that he steadily rose to grade level 7, step 1, before he suddenly took ill on or about 24th day of November 2025. The claimant applied for leave of absence on the ground of ill health on the 5th of November 2007, and it was approved by the defendant. And the claimant is to receive full salary and all his entitlement until his full recovery from ill health, and deemed it fit to commence work as a senior staff of the dependent on grade level 7, step 1. The claimant had been under medical management from 25th day of November 2007 till 3rd day of May 2014, when he was discharged but placed under medical checkup until he was certified fit to resume work. According to the claimant, during the period of his ill health, of which he was hospitalized, the defendant had withheld his salaries and all other entitlements, including earned allowances, from December 2007 until May 2018, when he was reinstated, after he had been certified medically fit to resume work by the report dated 14th day of August 2017, which has been tendered as exhibit in this case. The defendant reinstated the claimant wrongfully and maliciously as on salary grade level as senior craftsman on salary grade level 4, step 2, contrary to the terms of approval. The case of the defendant. The defendant case is to the effect that the claimant was employed on the 5th of May 1994 as a messenger cleaner. He never rose to level 7, step 1, before he abandoned his duty on or about 24th day of November 2007. The defendant insisted that the claimant forged letter and presented same to the defendant for reinstatement into the service, that the claimant was on grade level 4, step 2, when he abandoned dependent service. The claimant was never granted any leave of absence by the defendant, as the purported letter of 15th day of January 2008, which was said to have conveyed approval to the claimant to be absent from duty on ground of illness with pay, did not emanate from the defendant. The letter is fake. The defendant did not issue the said letter. On promotion, it was the case of the defendant that promotion to service is not automatic or as of right, but based on merit, as a staff must meet certain requisite criteria for being promoted. A staff must also possess certain minimum academic or technical qualification before being considered for upgrading. The defendant's criteria for assessment were also listed in the statement of defense of the defendant. The claimant never applied. The claimant never applied to the defendant for. It was the case of the defendant that the claimant never applied to the defendant for leave of absence from work on ground of ill health, as the purported letter of approval was not issued by the defendant whatsoever. The defendant operates in accordance with the extant laws, including conditions of service, and by its conditions of service, the defendant does not grant leave of absence on ground of ill health. The defendant never granted claimant absence from duty on ground of ill health with pay. The defendant denied withholding claimant salaries and allowances. Rather, the defendant averred that the claimant was and is not entitled to salaries and allowances for the period of his abandonment of duties. It was the case of the defendant that the claimant's salary was rightly stopped by the defendant, as the claimant was actually liable to termination for abandonment of duties, even in instances where the defendant grants sick leave to a staff. Such sick leave never exceed 6 months. The defendant admitted receipt of medical report on the 14th day of August 2017. But about that, the claimant abandoned the service of the defendant for over 11 years in contravention of extant rules and regulations and, and the conditions of service. The defendant reinstated the claimant in error as a result of purported approval for absence from duty, which turned out to be fake. The claimant was not entitled to letter of was not entitled to reinstatement for the period of abandonment of duty. The dependent father about that the claimant was actually liable to termination for abandonment of duties. It was also stated that the claimant was never on salary grade level 7, step 1. The dependent never withheld salaries of claimant. The claimant was reinstated on salary grade 4, step 2, was the level where claimant was before abandonment. The claimant was not supposed to have been reinstated for having abandoned his duties. The defendant insisted that the letter of 15th January was never issued by Dr. Mrs. Julia D. Oman, as she was not a registrar of the defendant as at 15th January 2008. Reply to the statement of defense. The claimant stated, file a reply. I have reproduced the reply. I will keep reading it. I have also captured the further defense of the claimant, of the defendants, which was filed a reply to the defense of, or a reply to the claimant's reply to the defense. I go to the submissions of the defendants. Jonas Abwo Esquire counsel for the defendant in the written address filed before the court donated single issue for determination. The argument on the issue has been captured in the body of the judgment. The submissions of the claimant, E.B. Eaton's, who franked the address of the claimant, formulated 3 issues in the written address and canvass argument on them. The argument of counsel has been captured in the body of the judgment. So I now go straight to the judgment of the court. I have taken time and calmly read through the parts and the evidence adduced by the parties. I have also taken time to scrutinize the several documents tendered and admitted in evidence. I have also considered the enlightening and weighty submissions of learned counsel for the parties, carefully noting the several decided cases relied upon by them. Coming to the determination of the claim before the court, it has been established by a long line of decided cases that the burden of proof in civil cases, like the case at hand, rests always on the party who asserts. Therefore, the burden is on the claimant in this case to prove that he is entitled to be granted the relief sought as per his complaint. In any event, the initial evidential burden of introducing evidence to prove a claim to a legal right or liability based on assertions of fact upon which right or liability is claimed is placed squarely on the shoulders of the claimant, and until it is satisfactorily discharged on balance of probabilities or preponderance of evidence as required by Section 134 of the Evidence Act, it does not shift pursuant to the Section 133, subsection 1 of the Act, of the Evidence Act. In this case, the claimant is the one that desired this court to enter judgment in his favor on the declaration and on the declarations and monetary payments being sought as per the 14 reliefs put forward before the court. Therefore, the claimants both Oyo Bare versus Omamu Chumo, Onuburuke versus Esegine, UTC Nigeria Limited versus Philip, and host of other cases cited therein. What emerges from the above cited cases is that burden of proof in civil cases is of two types. The first, which is termed as legal burden, relates it is the first, which is the legal burden, is the ability of the claimant as is for the claimant to establish his case by asserting positively to establish and prove the entirety or reasonable portion of his case before a court of law can give judgment in his favor. This is always constantly on the claimant. The other type is related to particular facts or issues which a party claim exist. It is this burden that oscillates from one party to the other, while the first burden is always on the party who assert. The other burden oscillates between the party depending on the pleadings and the facts. See the case of Ogule Ankpa Agata versus Cooperative Group Farming Society versus Nigerian and Cooperative Bank. See also Indul versus Wayo. From the 14 reliefs being sought by the claimant, from the 15 reliefs, from the 14 reliefs being sought by the claimant, the first to 6 reliefs are declarations, are seeking for declarations. Although declaratory reliefs are not granted, declaratory reliefs are not granted as a matter of course and on a platter of gold. They are only granted where credible evidence has been laid by the claimant or person seeking the declaratory relief. It is also the practice of court that a declaratory relief will not be granted where the claimant is entitled to the reliefs unless the plaintiff is entitled to the relief to the fullest meaning of the word. It is the law that in an action where claimant is claiming declaration, he must plead and prove his claim for declaratory relief without relying on the weakness of the case of the defendant. Also, where the weakness of the defendant's case supports the plaintiff's case, he can rely on such evidence to strengthen his case. A declaratory relief is not granted even on the admission by the defendant. See Anya, Anyaru versus Mandilas. See also Akim Boni and others versus Akim Tofe. See also Chukuma versus SPDC Nigeria Limited. See Uwosu Onwubufo and others versus Herbert Okoye and others. It must be emphasized that declaratory reliefs are not given just for the asking. A party seeking declaratory reliefs must satisfy the court by cogent and proven evidence that he is entitled to such declaration. It cannot be proved halfway. See the case of Mr. Joel Olayinka Salaja versus Chief Samuel Babatunde Osuforu Salaja. For relief 7 to 14, they are monetary in nature, except two that are for injunction. For the monetary reliefs, they falls within what in law is called special damages claim, in which the law requires it to be specifically and specially pleaded, particularized, and strictly proved. Where a party claims special damages, the burden is on him to prove his special damages by leading credible evidence, most of the time by documentary evidence, which shows the actual loss he suffered. Furthermore, unchallenged ipse dixit, evidence is not enough to prove special damages where the claim is required to be proved by documentary evidence. See the case of ATE and Co. Limited versus Military Governor of Ogun State. See also Young versus Chevron Nigeria Limited. See also UBN PLC versus Wanko. This means that special damages are such as the law would not infer from the nature of the act because they are exceptional in their character and must be claimed specially and proved strictly. That's why special damages are such damages suffered by a claimant that is quantifiable in money worth. A damage is special in the sense that it is easily discernible and quantifiable. It should not rest on a puerile conception or notion that would give rise to speculation, approximation, or estimation. In other words, when it comes to special damages, all the losses claimed on every item must be crystallized in terms of value before it is granted by the court. The Supreme Court has provided guide I'm online delivering judgment, Padai. What is the problem? You are the one who sent it. You are the one who generated the ID. I said they should contact you to send them. The ID I use on Monday. Yes. I said the ID I using. I'm online now. You can check from your side. Sorry, counsel. It is the other counsel that are supposed to join. There are two cases from Lagos I am to deliver on behalf of one of our judges. But they were complaining they have not gotten the sitting ID. Sorry for the interruption. The Supreme Court has provided guide as to what strict proof means when it comes to the issue of proof of special damages. This was in the case of Onyiro versus Onyiro, where it was stated as follows: strict proof does not imply unusual proof. Rather, it is basically proof that would bend or lend itself to quantification. The degree of strict proof depends on the character of the act that produces the damages and the circumstances under which the act was done. Strict proof means no more than that the evidence must show the same particularity as it is necessary for its pleading. It should normally consists of evidence of particular laws that is exactly known or accurately measured before trial. Strict proof does not mean unusual proof, but simply implies that a claimant who has the advantage of being able to base his claim upon a precise calculation must give the defendant access to the facts which make the calculation possible. Strict proof is in the concept of social damages can mean no more than such proof as would readily lend itself to quantification or assessment. In determining a case, the court is enjoined by law to restrict its consideration of the case to the reliefs contained in the claim. Put it differently, the court has no power to devise, to, to debate, or jettison the claim of the claimant as adumbrated by the reliefs. In other words, the claim is determined by the reliefs being sought. See the case of Gabriel Atibi versus Kabil Metal Nigeria Limited. This court will be guided by the principles of law enunciated in the above decisions in determining the entitlement of the claim of the claimant as per the relief sought before the court. It is clear from the pleading and evidence of the parties that the claimant was employed by the defendant, University of Calabar, on the 5th day of May 1994 on initial designation as messenger cleaner, salary grade level 1, step 1. The claimant's designation was changed on July 8, 1997 to senior craftsman technician on salary grade level 4, step 2. The defendant reinstated the claimant on the 24th day of May 2018. The defendant issued the claimant a query dated 19th day of July 2021. These are facts that parties are at them. There is no dispute on them. However, the parts on which parties are in dispute are not in respect of the validity of the claimant's leave of absence, approval with full pay, and the claimant's grade level prior to absence from duty. The claimant asserted that prior to his falling ill on 24th day of November 2007, he had progressed to salary grade level 7, step 1, and that the defendant approved his leave of absence on November 5, 2007 with full salary and entitlement until certified fit to resume as a senior staff member on salary grade level 7, step 1. The defendant denies this assertion that the claimant was on grade level and insisted that the claimant one was on grade level 4, step, step 2 at the time of absence and vehemently denied issuing any approval letter for leave with pay, claiming the document Exhibit C7, which compared the approval presented by the claimant dated 15th day of January 2008 is fake and was not issued by the defendant. The court dispute centers on the validity of the leave approval and the claimant's salary grade level at the time of absence. I have considered and appraised the evidence adduced by the parties on Exhibit C7 being fake as well as the claimant's grade level at the time of absence from duty on medical ground or otherwise. The defendant who asserted that Exhibit C7 is fake, forged by the claimant has the burden of establishing its assertion. In an attempt to prove Exhibit 7 to prove that Exhibit C7 was forged, the defendant tendered Exhibit D1, D2, D3, D4, D11, D12, D13, D14, D15, D16, and D17. I have I have scrutinized these documents. But one thing that should be remembered is that But one thing that should be remembered is that allegation of forgery is criminal in nature. Though made in civil case, the law requires proof of it to be beyond reasonable doubt. See Section 135 of the Evidence Act. Going through these exhibits tendered by the defendant, one will be right to say these exhibits have raised suspicion raised suspicions about the authenticity of exhibit C7, but the evidence is not strong enough to elevate it to beyond reasonable doubt. If it is true exhibit C7 did not emanate from the defendant, why has the, why has the signatory of exhibit C7, Dr. Mrs. Julia D. Omang, not called to deny signing the said letter? Furthermore, if it is true, as at the time exhibit C7 was said to have been issued by the defendant, Dr. Mrs. Julia D. Omang has not become registrar of the defendant, why has her letter of appointment as a registrar not tendered in evidence to show when she was appointed and resumed duty as registrar of the university? If the letter of appointment could not be produced at the trial, why has the defendant not tendered minutes of the meeting of the defendant's counsel approving the said appointment of Dr. Mrs. Julia D. Omar as registrar of the defendant? The absence of letter of appointment, minutes of meeting given minutes of meeting approving the appointment, as well as non-appearance of the signatory of Exhibit C7 to testify, has casted doubt on the claim of the defendant that the said Exhibit 7 has been forged by the claimant. Now, on the validity of leave approval and the claimant's salary grade level at the time of absence from duty, this depends on the provisions for such leave as provided for in the conditions of service. The defendant has tendered Exhibit D7 as the condition of service applicable, while the claimant is contending that Exhibit D7 is not applicable to this case. The leave, the leave, the leave which was granted by Exhibit C7 was with effect from 24th day of November 2008 to 24th day of May 2018, when the claimant was reinstated as per Exhibit D5. It is without doubt that as at 24th day of November 2008, when leave of absence was granted to the claimant as per Exhibit C7, Exhibit D7 was not in existence. It has not come into force, as it was then not made by the counsel of the defendant. Exhibit D7 came into force on the 1st of October 2014. This means Exhibit C7 could not have been contemplated, as at the time it was issued, could not have been contemplated by Exhibit D7 as at the time it was issued. The claimant has categorically stated his employment with the claimant is governed by a letter of appointment, Exhibit C3, and conditions of service. The claimant who is claiming benefit pursuant to conditions of service is duty bound to produce the relevant conditions of service applicable to his case for him to derive benefit from it. The failure of the claimant to produce relevant applicable conditions of service to the entitlement to leave as per Exhibit C7 is fatal to his case. The duty to produce conditions of service is on claimant and not on the defendant, as the court is only duty bound to look at the conditions of service in determining the entitlement of the parties, whether claimant or defendant. Since Exhibit D7 took effect from 1st October 2014, it will, as from that date, be the applicable conditions of service to the case at hand. However, prior to that, it, it is not Exhibit D7, which was made in 2014, that applies to the case of the to the case under consideration. There is no power available for granting leave of absence for more than 6 months in view of the provisions of Exhibit D7. Conditions of Service 2014. The leave of absence that can be granted shall not exceed 6 months as provided for by the condition of the service. This means that with the coming into force of Exhibit D7, the claimant ceased to enjoy leave of absence for more than 6 months. From Exhibit C2, the claimant was discharged from hospital on the 3rd of May 2014, but he did not report for duty until till 8th of June 2017, when he applied for reinstatement. The defendant, based on the claimant's application, supported by Exhibit C2, reinstated the claimant back to his job. See Exhibit C5. The action of the defendant in acting on alleged forged letter, Exhibit C7 and C2, and reinstating the claimant amount to waiver of whatever right the defendant have to discipline the claimant on alleged forgery. Since the said allegation was not investigated by the police and the claimant convicted for the said alleged forgery, this means the reinstatement of the claimant done by the defendant is valid and lawful and made in the exercise of the powers of waiver conferred on the defendant. So ordinarily the claimant, if he had been accused of misconduct, ought to have been punished and ought to have been punished. The defendant in this case choose to waive their right to punish the claimant by condoning his action. So they cannot complain, they cannot be allowed to complain now. On the dispute as to whether claimant ought to be or is on grade level 7 step 1 or grade level 4 step 2, the law is settled by a long line of decided cases such as Abegum versus Benue State Civil Service Commission, that promotion is a privilege and not a right. For a claimant to be entitled to promotion, he must establish his entitlement by satisfying the condition precedent for promotion, as promotion cannot be granted as a matter of course or for the mere asking. The claimant stated he had steadily rose to grade level 7 step 1, while the defendant denied that. This means that the parties having joint issues on this, then the duty is on the claimant who asserted the positive that he he was on grade level 7 when he took ill, to prove that he was actually on grade level 7. However, the parties are at addendum that by Exhibit C4, the claimant was redesignated from messenger cleaner to senior craftsman grade level 4, step 2. That has been admitted by both parties and need no proof. It is the claimant that is insisting on being on grade level 7, step 1. Therefore, he has the onus of satisfying the court that he is on that grade level. However, a scrutiny of the evidence and the pleadings of the parties will clearly show that there is no iota of evidence adduced by the claimant to establish that he has been on grade level 7, step 1, prior or from the date he was granted leave of absence as per XBC 7. The claimant having the claimant if he sorry the claimant who claimed to be on grade level 7, step 1, failed to tender his letter of promotion or to tender evidence that he has been enjoying the salary of grade level 7, step 1. The failure by the defendant to prove to tender his letter of promotion or pay slip enjoying the salary of grade level 7 means failure of the claimant to prove he was at any time on grade level 7, step 1. He cannot enjoy benefit attached to that grade level. This means all the claims respecting grade level 7 for salary arrears or shortfalls of payment fail and same are hereby refused accordingly because they are special damages which must be proved strictly. The claimant having failed to prove he cannot enjoy those benefits. Having found that the claimant has failed to tender relevant conditions of service to establish his entitlement to leave of absence and entitlement attached to it, as well as failure to establish being on grade level 7, all the claim respecting withholding of salaries and allowances between December 2007 and May 2018 also fail. They are also refused. It is tried law in labor law, claim of entitlements to benefit, i.e. allowances, is granted by conditions of service. Furthermore, such claim of allowances must be earned, i.e. the claimant must prove he really earned or worked for those allowances. In the case at hand, there is no dispute. The claimant has not worked for the dependent from 24th day of November 2008 to 23rd day of May 2018. This means claimant has not earned any allowance for the period in question. This means also that the monetary claim on allowances failed, same are hereby refused. The above exposition also shows that the claimant's salaries and purported earned allowances were never wrongfully withheld by the dependent from December 2007 until May 2018, covering the period of over 10 years. On the claim of malicious intent behind the query issued to the claimant by the defendant in July 2021, the claimant alleges that the query issued on 19th day of July 2021 is a malicious attempt to intimidate him for pursuing his legitimate demand regarding back pay and correct grade level. The law is settled that employer has an imputed right to discipline his employee for misconduct. Therefore, issuing query for misconduct cannot be cannot be said to be silencing claimant from pursuing his grievances. The query cannot be invalidated simply because claimant requests for his entitlement when it was issued to him. The case is built upon a clear the case of the claimant is built upon the entire case of the claimant is built around Exhibit C7, that is written approval by the defendant granting full pay during absence. However, it, it was found out that the claimant having his contract of service governed by conditions of service, the failure to produce the condition of service means failure also to prove his entitlement to any benefit, claim or any benefit, as Exhibit C7 is not the conditions of service. The conditions of service is sine qua non to claim for any entitlement regarding the contract of service. The court is only bound to look at the conditions of service in determining the right of the parties, and the onus is on the claimant who is claiming the entitlement to produce and adduce that document, to adduce that evidence before the court. Having found the claimant not to have done so, the claimant has woefully failed to prove his case by preponderance of evidence, and he is not entitled to judgment in his favor in this case. The claim of the claimant lack merit, same is hereby dismissed. I make no order as to cost. Yes, Registrar.
Yes,
My lord.
Okay. Sit down, address him.
Okay. My lord.
Yes.
Talk.
Yes, my lord. The defendant want to, at this point, express profound thanks to the court for doing justice.
I'm doing my duty.
Yes, my lord. My lord, we appreciate the industry of this court that justice has been served.
It's all right.
Thank you, my lord.
Registrar.
Yes, my lord.
What's the next case?
As the court pleases, suit number NICN CA 51M 2024 between Dr. P.G. Akintunde and 1. University of Calabar, 2. The Vice Chancellor, and 1. United Bank for Africa PLC, 2. First Bank of Nigeria PLC, 3. University of Calabar Microfinance Bank, 4. Access Bank PLC, 5. Eco Bank PLC. My lord, all the parties are absent.
But you should have called the one that parties are here. I ask you.
No, my lord.
All the parties are.
My lord, it's the parties that are absent. The councils are online.
Okay.
Yes, my lord.
Appearance.
Good afternoon, my lord.
Yes, sit down. Announce your appearance.
Just joined. I don't even know which matter was called, my lord. We're just in the wrong Zoom meeting. I will just join now. We're just giving a fresh link to join this meeting, sir.
You listen to the registrar. The case she has called is NICN/CA/53M/2023. So if you are in that matter, you announce your appearance. If you are not in that matter, you wait for your turn.
Okay. She didn't mention the name of the party, my lord.
She has mentioned Dr.
It's Dr. P.G. Akintunde
versus University of Calabar.
Okay. Thank you, my lord.
Yes, appearance.
With utmost humility to this honorable.
Yes.
S.N. Brown, my lord.
S.N. Brown.
N, yes, my lord. N as in no, my lord.
Yes.
Chief Legal Aid Officer.
Appearing for who, Brown?
My lord, appearing for the judgment creditor respondent.
Please, you can sit down.
Thank you, my lord.
Yes, any other appearance?
With profound respect, my lord, Jonas Abuo appears with Agnes Atrogo, holding the brief of Paul Ishemomo, Esquire, for the judgment debtor applicant, University of Calabar.
We are holding brief of Paul Eshemomo. Mr. Abu.
Holding the brief
Yes.
of Paul Ishemomo for the judgment debtor applicant.
Yes, any other appearance? No appearance for the garnishes? Okay, this is ruling of the court. This deal with motion on notice dated 4th day of August 2025 and filed on the same date. The motion was brought pursuant to Order 17 Rule of the National Industrial Court of Nigeria, Civil Procedure Rules 2017, Section 36 of the Constitution of the Federal Republic of Nigeria, and under the inherent jurisdiction of the court. In the application, the judgment debtors applicants are praying for an order setting aside the garnishee order NISI made by this court in the proceedings of 5th day of June 2024, having been granted without jurisdiction. 2, an order setting aside the garnishee order absolute made in proceedings of 25th day of July 2025, having been premised on a void order NISI, and for such further order and other orders as this court may deem fit to make in the circumstances. The ground for this application are as set out on the face of the motion paper, that this honorable court did not possess the requisite jurisdiction to entertain the proceedings and grant the orders. The conditions precedent for the commencement institution of the garnishee proceeding by the judgment creditor respondent was absent. By this reason, the orders of the court first above mentioned are null and void. The facts contained in the judgment creditor respondent affidavit in support of the motion ex parte upon which the garnishee order NISI was made did not disclose any cause of action against any of the garnishee bank. None of the garnishee banks was indebted to any of the judgment debtors at that time. The application for the order NISI was made by the judgment was made at the time the order NISI was made. Paul Eshemomo Esquire, counsel for the judgment debtor applicant, in arguing in support of the application, informed the court that he is relying on 11 paragraphs affidavit in support of the application and the exhibit attached therein. Counsel also adopted the written address filed along with the motion on notice as his argument in this application. In the written address, 4 issues were formulated for determination. I will escape reading them. The judgment creditor respondent filed 13 paragraphs counter affidavit in opposition to the application. A written address was also filed along with the counter affidavit, which was deemed as having been argued due to absence of counsel to argue same when the application came up for argument before the court. I have considered the processes filed in this suit as well as evaluated the affidavit evidence filed by the parties before the court. I have equally appraised and considered the cases cited by the counsel in support of their various submissions. The main reliefs being sought by the judgment debtors applicant is for setting aside of the order NISI of 5th day of April 2004 and order absolute of 25th day of July 2025. The said orders were said to have been made without jurisdiction. Jurisdiction is threshold that gives court power to adjudicate over dispute submitted to it by parties, without which any order made will be a nullity, will be null and void, no matter how well the proceeding was conducted. In determining jurisdiction, the court is enjoined to consider the claim before being sought, as it is the relief sought that compass jurisdiction. If they fall within the ambit of the jurisdiction of the court as encapsulated in the Constitution or statute conferring jurisdiction, the court will assume jurisdiction. In the case at hand, the relief sought by the judgment creditor respondent is enforcement of judgment of this court. The critical question that need to be answered is whether the court has jurisdiction to enforce its order in the way it has done in this case. Garnishee proceeding are statutory method of enforcing a monetary judgment, allowing a judgment creditor to attach money belonging to the judgment debtor in the hands of a third party, the garnishee. Typically, a bank, as in this case, the process is initiated by an ex parte application for an order nisi, which is provisional order requiring the garnishee to show cause why the money should not be paid to the judgment creditor. If no sufficient cause is shown, the order nisi is made absolute, compelling the garnishee to pay. See section 83(1) of the Sheriff and Civil Process Act, which is the enabling statute stipulating that the court may make an order nisi upon affidavit by the applicant or their legal practitioner that judgment has not been recovered and that it is still unsatisfied and that any other person is indebted to such debtor and is within the state. This section lays down the fundamental conditions precedent to the commencement of garnishee proceeding. See also section 287 subsection 3 of the Constitution on the powers of the court to grant or to entertain garnishee proceeding. A careful perusal of the motion ex parte and the affidavit in support filed on the 5th day of February 2024, coupled with the affidavit to show cause filed on the 24th day of June 2024 by the first garnishee, the order nisi was made in compliance with the provisions of section 83, subsection 1 of the Sheriff and Civil Process Act. For proper appreciation, paragraph 3 of the affidavit of the first garnishee read, and I quote, that Chukudi Ether, the legal officer of the first garnishee United Bank for Africa, informed me on the 20th day of June 2004 at about 10:53 a.m. or so soon thereafter via email. The email address has been given is there, and I truly believe him that upon service of the order nisi of this honorable court on the first garnishee, he has perused the bank record and confirmed the following: A, that first judgment debtor maintained 4 accounts with the garnishee, whose account numbers reside with the first garnishee bank as follows. I have quoted the account numbers. B, the available balance in the accounts of the first judgment debtor are sufficient to satisfy the judgment sum in this case. C, that the second judgment debtor does not maintain any account with the judgment creditor. The above abatement has clearly debunked the ground of this application and the abatements of the judgment debtors in the affidavit in support of the application, to the effect that the first garnishee's affidavit shows that account did not belong to any of the judgment debtors applicant, but to University of Calabar Trust and Endowment Fund, a company limited by guarantee. It is pertinent to note in the affidavit to show cause filed by the first garnishee, it was made unequivocally clear that by the paragraph 39b that the available balance in the account of the first judgment debtor are sufficient to satisfy the judgment sum in this case. It was on the strength of the abatement confirming availability of funds to satisfy the judgment debt in the account of the first judgment debtor that this court granted the order nisi of 5th day of June 2024, which was subsequently made absolute on the 25th day of October 2024. It is true that the judgment debtors do not have any. If it is true that the judgment debtors do not have any account with the first garnishee, I do If it is true that the judgment debtors do not have any account with First Ghana, then what is the business of the judgment debtors applying for the court to set aside its other nicer? Why I cannot understand why the judgment should be worried about the assertion of the first Ghanashi. They should allow the owner of the accounts to fight for it. Since they claim they do not have accounts, what will they suffer with the other nicer made and subsequently made absolute? They stand to lose nothing since they are not owners of the said of the accounts in which the Ghanashi said there are sufficient money to satisfy the judgment of this court. I have no doubt in my mind with the abandonment contained in the affidavit to show cause the conditions precedent as stipulated by Section 83, subsection 1 of the Sheriff and Civil Process Act have been fulfilled. Therefore, the orders of the court cannot be faulted, and this court cannot set aside those orders. The judgment, as they were made with requisite jurisdiction, the judgment debtors applicant have not made out any case to justify setting aside the order nicer and order absolute made by this court in this case. The way and manner counsel has been inundating this court with application challenging jurisdiction of this court to hear and entertain Ghanashi proceeding clearly shows that the judgment debtors are all out to go to any extent to prostrate the judgment creditor in this case from reaping the benefit of the judgment of this court. The judgment debtors have not in any way disputed the judgment sum, which the judgment creditor has taken legal steps to ensure compliance. It is because the judgment debtors applicant do not want to obey the court order. That's why they are resorting to using judicial process to prostrate the judgment creditor in order to deny him of the enforcement of the judgment given in his favor. Also, take into consideration the judgment debtors have in another application before this court challenged the order nicer, which they are also challenging in this case. The judgment debtors are engaging in abuse of court process, as at the time they filed the application of 13th day of August 2024, they are aware of the existence of order nicer of 5th day of June 2024, but they decided and choose to only challenge order absolute. Therefore, the present application wherein they are challenging both the order nicer and order absolute amount to abuse of court process. The reason being that as at the time they were challenging the order absolute, which this court delivered its ruling and refused the application, the order nicer was in existence. They cannot claim ignorance of its existence. Therefore, challenging the two orders after the challenge to the order absolute has been thrown out by this court. Has been thrown out by this court amount to abuse of court process. They engage in using the process of the court to harass the judgment creditor. In view of the foregoing, even if there is no compliance with condition precedent, the judgment debtors application for setting aside must fail because parties are not allowed to ventilate grievances in piecemeal. On the whole, the application for judgment debtors applicant failed. Same is hereby dismissed with cost of 200,000 naira granted in favor of the judgment creditor respondent. Ruling is hereby entered accordingly.
As
As the court pleases. My Lord,
Yes.
my Lord, we want to, on behalf of the judgment debtor applicant, thank my Lord for the industry. At least we also take the hint of court. Justice has been served. Thank you so much, my Lord.
You are welcome. Registrar,
yes, my lord.
call the next case.
Suit number NICN LA 308-2016 between Mrs. Rose Inenemo Onugbe and Union Bank of Nigeria PLC. My lord, the parties are absent.
Okay.
Respectfully, my lord.
You come here, I will call for appearance. You know, I have not even read the judgment, so I'm just seeing it for the first time. So let me,
Okay, my lord.
just give me 1 minute. Your own is Mrs. Rose. Counsel, that
Yes,
want to
my lord. Mrs. Rose.
appearance.
Yes, my lord.
Okay. You can go ahead and announce appearance.
Okay. Respectfully, my lord. My name is
Yes.
Stephanie Ukonga Ojekere. Stephanie Ukonga Ojekere. Ukonga Ojekere is a compound name. UKO NGA
OKO.
hyphen
Counsel.
UKO
Wait, I'm coming. You said Stephanie who?
Ukonga Ojekere.
Okonga.
Ukonga
OKO.
Ojekere is a compound. UKO, my lord. U for
UK.
umbrella, my lord. UK. Yes, my lord.
UKO.
U UKO
Yes.
NGA
NGA.
hyphen
Yes.
hyphen OJEI
OJ.
EI.
Counsel, you have to make yourself available for me to record you. If you cannot make yourself available, I can record you. You are absent.
Mate, please, my lord.
Yes.
Toyib Abodunde is my name.
OE.
Toyib, Toyeb.
O.
Toyeb.
Double
Abodunde,
ED.
yes, Abodunde is spelled as pronounced.
Your second name?
Abodunde,
Abodu.
ABO, yes,
Abodu.
ABO,
Yes.
ABO,
Are you appearing for who?
for the defendants, my lord.
Yes, the counsel for the claimant, you are absent until you make yourself available.
My lord,
I'm present, my lord.
You said?
No,
You have to make yourself available on your camera if you want me to record you. I have to see your face before I record you.
As the court pleases.
Yes, this is the judgment of the court. I'm reading it on behalf of Justice Gwandu, who is indisposed. Our rules allow that. The claimant commenced this suit via a general form of complaint filed on the 11th day of May 2016, which was further amended on the 13th day of June 2017, and sought the following reliefs. I'm going to skip reading the reliefs. They have been captured in the body of the judgment. I think the reliefs are 12 in number. They are 12 in number, and in the alternative, to remedy the claimant sought for an order of this court that the dependent pay claimant redundancy benefit in line with Article 5 of the collective agreement. In the alternative to H, he sought for an order of this court directing the defendant to pay the claimant 1 month salary in lieu of notice and payment of severance benefit in line with the agreement of the defendant and the union on 30th day of September 2014. They are also asking for other reliefs. There is an order for 14 million naira and 5 million naira. Okay, 14, an order for the payment of gratuity arrears of 14 million naira, 404,251 naira, less 5,998,380 naira already paid to the claimant. The last relief 16, is an order for the dependent bank to pay the sum of 45,300,000 naira as damages compensation calculated on the basis of the remaining 12 years the claimant would have been in the employment of the dependent for the wrongful and unlawful termination of claimant's employment. In response to the claimant amended statement of facts, the dependent filed a statement of defense dated 8th of August 2016 and 2nd of August 2017. The claimant filed a further amended statement of facts and thereafter filed an additional witness statement on oath on 29th day of October 2018. The defendant filed a further amended statement of defense pursuant to defendant's further amended statement of defense. The claimant filed an additional witness statement on oath on the 29th day of October 2021. Brief statement of facts. The case of the claimant is that determination of her employment was wrongfully as the same was done without regard to her contract of employment and the collective agreement of ILO Convention, collective agreement, ILO Convention 158 and ILO Recommendation 166, that she was never paid the 1 month salary in lieu of notice, nor paid 50% of severance pay, pursuant to the agreement dated 10th day of September 2013 between the Dependent Association of Senior Staff of Banks, Insurance, Financial Institution, and National Union of Banks, Insurance, and Financial Institution Employees, NUFE. Furthermore, the dependent deducted already earned income from her gratuity entitlement and based the computation of gratuity based the payment of gratuity entitlement on basic salary, housing, lunch, and transport instead of basic salary and all allowances. The dependent case is that it terminated the claimant's employment in accordance with the contract of service signed between the claimant and the dependent. The dependent states that in accordance with clause 7 of the claimant's contract of service, either party can determine the employment by providing 1 month's notice, by providing 1 month's calendar notice in writing, or the dependent's pay to the claimant 1 month salary in lieu of notice. The dependent said it deducted the sum of 39,963 naira 23 kobo and 99,555 naira 22 kobo from claimant's account on unearned housing allowance and loan borrowed by the claimant while in the service of the dependent. The dependent states that it paid the claimant gratuity in full in accordance with the dependent trust deed of variation 2004. The dependent states that the claimant was paid her arrears of basic salary and allowances in full, and the claimant is not entitled to any arrears whatsoever. Trial commenced on the 3rd of July 2019, and the claimant opened her case and was examined in chief. The claimant adopted 3 witness statement on oath dated 11th May 2016, 12th August 2016, and 29th day of August 2018. On the 18th of November 2019, the claimant was cross-examined and no examination was done. The defendant opened its case on 19th of February 2025. The defendant's sole witness, Mr. Francis Idibe, adopted his witness statement on oath filed on 6th of July 2021 and tendered same document. The defendant's witness was cross-examined and thereafter re-examined by the claimant's counsel. Trial was concluded and the matter was adjourned for adoption of final written addresses. Defendant's argument. Defendant formulated 5 issues. The arguments on the issues have been captured in the body of judgment, so I will skip reading the argument due to time constraint. The claimants also formulated 3 issues for determination. The argument of the claimant have been captured in the body of the judgment. I shall also skip reading the argument. I will go straight to the decision of the decisions of the court. There is also reply on point of law. The argument on the reply has been captured in the body of the judgment. So I skip reading the argument. I now go straight to the decision of the court. I have read the processes filed, the submissions of counsel, as well as heard the testimony of witnesses of parties in this suit from the issue raised by the claimant in their by the counsel in their respective final written addresses. I have distilled the following issues for determination by this court. The issues are: 1, whether the termination of claimants for services no longer required accord with the contract of employment and international best practices. 2, whether the claimant's termination amount to redundancy which entitles the claimant to redundancy benefit. 3, whether the claimant has been able to prove relief sought against the defendant. On the first issue, whether termination of the claimants for service no longer required accord with the contract of employment and international best practices, the claimant relied on Article 7 of the ILO Termination of Employment Convention 1 of the Convention 1982 and paragraphs 8 of ILO Termination Recommendation 1982, which provide thus. I will skip reading the quotation. The claimant states in her statement of fact that the defendant accused her of fraud, reported her to the police, which arrested and detained her, and was subsequently arraigned before Iboshere Magistrate Court, which found her not guilty of the offense and acquitted her. She said she reported back to the office and gave her notice to resume via a letter dated 2nd day of June 2015, after which she was given a suspension letter backdated to 25th day of March 2014, which she signed on the 9th day of July 2015, and her employment was thereafter terminated by the defendant for service is no longer required. The defendant relies on Clause 7 of the court which said that notwithstanding anything herein contained, either of the bank or official may determine the agreement at any time given to the other 1 calendar month's notice in writing in that behalf, but the bank shall have the right to pay to the official 1 month salary in lieu of notice, and argued that based on these provisions, the defendant does not need any reason before it could terminate the service of its employees. In Damisa versus UBA, the Supreme Court held and I quote, a master reserves the right to dismiss an employee at any time. However, the dismissal must be as specified in the letter of employment, the contract of employment, or whichever document that regulates the employment relationship. An employer is entitled to terminate an employee's employment for no reason at all. Where a reason is given, however, same must be justified. While the court affirms the age-long common law practice which entitle employer to hire and fire an employee at will and for no reason at all, I will not be relying on same in this case as presently constituted. The claimant in his present case has, however, activated the jurisdiction of the National Industrial Code, which enables it to interpret and apply international best practices where it deems fit. In this case, see Order 14A of the National Industrial Code Civil Procedure Rules. The claimant has pleaded and relied on Article 7 of the ILO Termination of Employment Convention 1982. The defendant has made no argument against the application of the said instrument as against the said international treaties. I therefore take it that the defendant admits this honorable court by the jurisdiction vested in it by Section 2541 F and H of the Constitution of the Federal Republic of Nigeria 1999 as amended, and Section 7 subsection 1 subsection 6 of the National Industrial Code of Nigeria Act which enjoin the National Industrial Code to have due regard to fair labor practices and to good or international best practices in labor, employment, and industrial relations when examining its exclusive jurisdiction over labor and employment matters, can hear and rely on international best practices in international best practices in its decision. More so, this honorable court cannot ignore the circumstances which led to the arrest, suspension, and termination of the claimant's employment. Exhibit RJU 11 is an invitation to appear before a disciplinary committee staff disciplinary committee dated 12th day of May 2015. Exhibit RJU 12C is a memo of suspension dated 25th day of March 2014, which was received by the claimant on the 9th day of June 2015. Exhibit RJU 13 is the memo recalling the claimant from suspension dated 7th day of July 2017, and Exhibit RJU 14 is a letter of termination dated 31st day of July 2015. From the timeline, it can be seen that claimant was never handed a letter of suspension before she was placed on suspension. This is already a violation of the terms of employment of the claimant against RJU 9A to G. Is a judgment of the Magistrate Court Iboshire delivered on the 15th of April 2015 before the claimant was handed a letter of suspension and called to disciplinary hearing. On the same matter, she was discharged and acquitted for. I dare say even the defendant must see how the timeline of event and subsequent termination of the claimant employment would look to a bystander who looks at the facts before this court. While the employer, by common law, can terminate the employment of its employee, the employer must, by ILO convention and treaties, give a reason for termination of the service of its employee by the new dimension. This court, being the first, a court of equity, must preserve the security of employment. Look at the equitability of termination in cases brought before it, apply common law where it seems fit, and equity where it warranted. The application of ILO convention and treaties are equitable applications which better regulate the employment space in Nigeria and protect the job securities of Nigerians. Also, at the point of the defendant accused the claimant, reported her to the police, charge and arraign her before a competent court. It removed the rights to terminate her upon resumption without reason. As from the point of view of the court, it looks and feels like retribution against the claimant, especially after she was found not guilty by the court for no reason at all. She is in violation of Article 7 of ILO Termination of Employment Contract 1982, and also coupled with the fact that the defendant has not shown the court if it followed strict compliance with the terms of employment. The defendant is relying on clause 7 of the contract of employment, did not show the court it paid the claimant 1 month salary in lieu of notice of termination as mandated by the said clause. It relies on counsel's argument, cannot take the place of evidence arguing the claimant was paid and showing the court where or how the claimant was paid are two different things. The court will not speculate on behalf of the defendant. I hereby hold that the termination of claimant for services no longer required is in violation of the terms of employment between the defendant and the claimant and Article 7 of the ILO Convention. On the second issue, whether the claimant's termination amount to redundancy, which entitles the claimant to redundancy benefit, the claimant relies on Exhibit Idia B2, page 1 to 2, which is collective agreement between Nubipe and Asipti, and the defendant dated September 2013. The defendant has argued that the collective agreement was not incorporated into the claimant's contract of service, and as such, her assertion goes to no issue. I say this is a weak argument. The claimant has shown by the cogent evidence of her pay slip that she was a member of ASIPTI. The defendant did not argue that the collective agreement is not inoperative, but it is inapplicable on account of it not being incorporated to the claimant's term of employment. The defendant's handbook exhibit RJU2, page 1 to 57, volume 4, page 1, under SUB head General provides in all matters affecting staff attention must be paid to any current union agreement to which the bank is a party. Such agreements are binding upon the bank and are to be observed in the spirit as well as the letter. At page 21 of SUB subhead handbook ratifies any collective agreement which this by the defendant's handbook ratifies say collective agreement which is imposed and incorporates same into the terms of employment between it and its staff. It is, however, the claimant case to prove redundancy, as he who asserts must prove. See Anibaba Dana versus Dana Airline Limited. The court in Obibi versus Delta Steel Company Limited held that redundancy procedure in Nigeria are governed by the following: the Nigerian Labour Act, B, the decision of the court, that is case law, the employment contract of the affected employee, and employment handbook. The provisions of any collective bargaining agreement between employer and its employee representatives as a trade union applicable to international best practice. The claimant is in this suit has sought to rely on the Labour Act and the collective agreement. However, the court in Nigerian Society of Engineers versus Ozo had distinguished redundancy as the termination of appointment of an employee in a bracket of its own for removal from the incident of an employee leaving service because of redundancy. Termination of appointment implies compliance with severance of an employee relationship by disposing with the services of an employee with his post extant, while redundancy implies that the post occupied by the employee is no longer necessary and or useless to the employer. The Supreme Court affirmed this decision when it held in Obibi versus Delta State. Redundancy in service is a mode of removing an employee from service when his post is declared redundant by his employer. Redundancy is a form of redundancy permanent reminder from removal from office. It is therefore not a voluntary retirement, nor is it a dismissal from service. It is also not a voluntary or forced resignation, nor is it a termination of appointment. Rather, it is a unique procedure whereby the employee is lawfully relieved of his appointment. The conditions applicable to redundancy are quite different from those applicable to retirement or other conventional mode of relieving an employee from service, such as termination, resignation, or dismissal. The claimant in this suit has alleged wrongful termination and proves same. It will therefore be contradictory if the court finds for redundancy, where the appellate court have held that redundancy is a special form of relieving of employee of his employment and it is distinct from dismissal or termination. More so, the claimant must prove the element of redundancy, which she has failed to do in this case. Reliance on only the collective agreement will not suffice as it is, and the court cannot speculate on the incidence of redundancy either. I hereby hold that claimant has failed to prove her termination amount to redundancy. On the other hand, on whether the claimant has been able to prove relief sought against the defendant, the claimant first relief against the defendant is for declaration that the purported termination of employment of the claimant is unlawful and wrongful, as the said termination was done without regard to contract of employment collective agreement. This relief is granted as for the reason given above. On the relief for a declaration that purported termination was without reason and not in line with the international best practices and recommendation is also succeed and is granted accordingly. On the claim, relief for declaration that the non-payment of severance benefit based on 150% total emolument to the claimant when same was paid to a colleague is unlawful and discretionary. The claim discriminatory, sorry. The claimant did not prove redundancy under the collective agreement. Thus, this relief fails and is refused. The claimant relief for a declaration that the termination of her employment for services no longer required amount to redundancy is also refused. The claimant relief for declaration that dependent bank is in error in its arrears of the claimant's gratuity in the sum of 14 million already paid less 5 million already paid to the claimant. The claimant adduced evidence that the 1996 trust deed is what is in use by the defendant and not the 2004 pension trust deed. Shall tender evidence which shows the defendant paid gratuities based on the 1996 trust deed after it claimed the 2004 deed had come into effect. The inconsistency surrounding defendant's 2004 deed has led to the court to doubt its veracity, and the defendant has not shown the court otherwise. Its defense on this is weak and does not address the issue raised by the claimant in her statement of fact. Succinctly, based on this, I will rely on the 1996 trust deed as the operational document in this case, and this means claimant was underpaid her gratuity in terms used in paying others in the time frame. In the time frame of her termination. This relief is hereby granted as spread. On the claimant's relief for declaration that the deductions and earned housing of 39,000 and 99,000 made to the gratuity paid by the defendant to the claimant is unlawful, null and void. The claimant has admitted that she took a loan from the defendant. It was communicated to her in the breakdown of her indebtedness and benefit. However, the defendant has not shown to the Honorable Court when the loan was taken, how much was taken and paid, and the structure of what it paid or left. It cannot justify these deductions by cogent evidence. Also, the deductions of an earned housing allowance cannot be justified. The claimant's suspension made it mandatory that the reports to the office payment made to the claimant accounts are automatically earned as far as this honorable court is concerned, and the right procedure on deduction of wages outlined by Section 5 of the Labour Act. This relief succeeds and is hereby granted accordingly. On the claim relieves for a declaration that the withholding of the claimant's 150% exit package of her basic housing, transport, and lunch allowances of 1.5 million is in line with the agreement between the dependent associations of staff of banks, insurance and financial activity and MIVP dated 10th September is wrongful, unlawful, and discriminatory, and a declaration that the dependent bank is in arrears of the claimant's 150% package. The claimant has not proved these reliefs and they are hereby refused. On the claimant's relief for an order of this court compelling the dependent bank to reinstate the claimant to her employment, which was terminated without due process or procedure laid down by the dependent bank's handbook and collective agreement. This honorable court cannot foist a willing employee on an unwilling employer, especially where the employment was not statutory labor. See Damisa versus UBA. On the claimant's release for an order for the refund of deductions of an earned housing of 39 and 99. The claimant succeeds and is granted as prayed. On the claim relief for an order for payment interest of 15% on payment under JNO from 4/9/2015 till date of liquidation. This relief is refused. The claimant relief for an order that the dependent bank be in arrears of the claimant's 150% exit packet pay to the claimant the sum of 3.9 million naira. that the dependent pay the claimant redundancy benefit in line with Article 5 of the claimant agreement. This relief fails and is refused. On the alternative reliefs, for an order of court directing dependent to pay the claimant 1 month salary in lieu of notice or payment of severance benefit in line with the agreement of the dependent and the union on 30th day of September 2014, the dependent is ordered to pay to the claimant 1 month salary in lieu of notice. On the claimant's relief for an order for payment of gratuity arrears, less 3.9 already paid in the claimant, this relief succeeds and is granted. On the claimant's relief for an order that the dependent banks pay the sum of 45,300,000 naira as damage compensation calculated on the basis of the remaining 12 calendar months would have been in the employment of the dependent for wrongful and unlawful termination in employment. This relief fails and is refused accordingly. This is the judgment of this court and it is entered accordingly. Signed, Honorable Justice R.S. Gwandu, Judge.
As the court pleases.
As the court pleases.
Yes.
I'm most grateful, my Lord. Thank you for the well-detailed judgment. Thank you, the Lord, my Lord.
Yes, Registrar,
appreciate-
call the next case.
As the court pleases. Suit number NICN LA 275-2021 between Henry Nwabo and 28 others and Union Bank of Nigeria PLC. My Lord, the parties are absent.
Okay.
Respectfully, my Lord.
Wait, counsel. Yes, and appearance.
Respectfully,
Appearance.
my Lord.
Yes.
Yes, my Lord. Stephanie Ukunga Ojekere.
Stephanie
Ukunga Ojekere. I appear for the claimant, my Lord.
Okay.
The greatest respect to my Lord.
Wait, I'm coming. Yes.
With greatest respect to my Lord. My name
Yes.
is P.O. Omobude.
Omobule.
Omobude is spelled
Omobule.
O-M-O.
Yes.
P-H-U-D-E.
Yes.
P-H.
Are you appearing for who?
I'm appearing for the defendant.
This is judgment of Justice Gwandu, R.H. Gwandu, which I'm reading. By an amended general form of complaint dated 3rd of June 2022, the claimant commenced this action against the defendant, seeking the following reliefs. The reliefs have been reproduced in the body of the judgment. They are 9 in number. In opposition to the claimant's claim, the defendant filed an amended statement of defense on the 10th of August 2022. Brief facts of the case. The case of the claimant is that upon their premature retirement, the defendant paid them various sums of gratuities using their basic salary, housing, transport, and lunch allowance instead of basic salaries and all allowances. The wrong parameter used resulted in the short payment of their gratuity entitlements. The claimant became aware that the computation of their gratuity should have been based on their basic salaries and all allowances. After the decision in suit number NICN/LA/806/2016, the judgment of which was delivered on 6 February 2020 by His Lordship Honorable Justice R.S. Kwandu and NICN/LA/160/2017, the judgment of which was delivered on 30th June 2020 by His Lordship Honorable Justice P. Gwan R.S. P.A. Basi. It is also the case of the claimant that upon the termination of their employment, the defendant deducted various sums of money already earned income from the terminal benefits of the said paid to them in breach of their contract of employment, Article 8 of ILO Protection of Wages Convention 95, 1949. The ninth The defendant contended that the claimant contract of employment is governed by the individual letters of employment, trust deed, and policy circulars, and that there is no provision in the claimant's contract of employment or trust deeds that give the claimants the right to remain in the defendant's employment till they attain the age of 60 years. The defendant further contested that the claimant's gratuities were paid correctly in line with the dependent trust deed of variation and the dependent circular 18/97 on the basis of basic salary, housing allowance. Also, that the suit was statute bar and also an abuse of court process. Defendant's argument, the defendant's final the defendant formulated 4 issues for determination. The issues and argument have been captured in the body of the judgment, so I shall skip reading them. I go to the decision. I'm trying to skip skipping the yes the yes I have skipped the argument of counsel and on the various written at this file. Yes, I shall now consider the court decision. His Lordship commenced by I have gone through the processes file, read the submissions of counsel, and heard the testimony of witnesses brought before the court by parties to this suit. From the issue raised by claimant in this suit, two issues were distilled by his lordship. They are: one, whether this action is statute barred, thereby robbing the court of jurisdiction. Two, whether on the preponderance of evidence, the claimants have proved entitlement sought against the defendant. On the first issue, on statute bar, the claimants argue that the course of action of their case arose after the judgment of Honorable Court, which was delivered in June 2020, while the defendants maintain that the claimants' course of action matured when they were paid their employments employment were terminated and their gratuities paid. The court in Idris versus NNPC held that the course of action can only be gleaned from the writ of summons and statement of claim of a plaintiff and not from statement of defense. I therefore must look at the claimant's statement of claim as the document to see when course of action arose. It is on record that this claimant were terminated from the employment of the defendant between 2010 to 2014. The statement of facts does not outline the details of individual exist, but their letters of termination states it is on record that the claimant were terminated from the employment of the defendant between 2010 to 2014. The statement of fact does not outline the details of individual exist, but their letters of termination. It is on record that the claimant were terminated from employment of the defendant between 2010 to 2014. The statement of fact does not outline the details of individual exist in their letters of termination. In paragraph 20 of the amended statement of fact, claimant states that they got to know that their emolument, including basic salary and allowances from the judgment debtor in this case, they believe their course of action arose in 2020 and not as at point they exist. It has been pointed out, it has been a point of controversy whether employment contracts are subject to limitation of law, with the appellate court going back and forth on this issue. This, however, has been put to rest by the Supreme Court decision in the case of Chukwuka versus Okoronko versus Ike held any action commenced outside the time stipulated by the FOPA statute barred. This means the Honorable Court will put the claimant's case on the determinant test accordingly. After I took a holistic look at the claimant case, I determined that the claimant's course of action approved on the 13th day The claimant's course of action accrue on the dates their employment with the defendant came to an end. Came to an end, okay. Came to an end and they were paid their exit packages. I arrived at this decision being considered two pertinent issues. That the issue which combination make up of claimant's course of action arose at their individual exits. See Ethiopia Airline versus Polaris Bank, where the Supreme Court held the course of action cannot a combination of facts which, if proved or substantiated, entitles a party, a plaintiff, to an enforceable right remedy against wrongdoer, the defendant. It consists of two elements: the wrong act of the defendant, which bestow course of action on a plaintiff, and the consequent damage. The court had held the capacity the courts have held the equity have held that equity aids the vigilant. The claimant were thus not vigilant, where they waited for another person to sue and get judgment, which according to them revealed their course of action. They should have been more vigilant, as Awoni Ayewumi stated. The course of action cannot be suspended by way of ignorance or even illiteracy. See Olateju versus Community L&H Kwara State. It is only either continuous, which is an exception, or caught up with the limitation law. The claimant course of action arose when there was an enforceable act. The claimant's course of action arose when there was an enforceable act that they were not paid in accordance with the difference put they allege. The claimants were paid and received their individual exit payment. This excludes them from challenging the sum paid at this point. See the case of Yusufu versus Donia Aviation, where it was held a person who accepted an offer of employment under a remuneration structure and received the emolument paid under the structure by his employer without complaining, and also accepted his termination benefit under same In the instant case, the appellant accepted their employment, emolument, and their terminal benefit under respondent senior staff remuneration structure without any complaint. Consequently, they were precluded from asserting that their terminal benefit ought to have been computed on the basis of National Association of Aircraft Pilots and Engineers salary structure. The claimant in this instant suit have not shown the court that they ever protested the terms on which they were employed, that they protested the terms by which they were paid. They were paid only, that they were paid and have now come because someone else challenged the basis on which they were paid. This argument cannot avail the claimant in this case. Sorry. Based on the foregoing, I hereby hold that the claimant's course of action in this present suit, as constituted, has been caught up by Section 8 of the Limitation Law of Lagos State, which says that this action cannot be brought after 6 years of the accrual of course of action. See Nigerian Agip Limited versus Malabu Oil and Gas Limited. Having held that the claim and course of action is started back, this honorable court is therefore lack jurisdiction to hear and determine the issues raised therein. See Ethiopia Airlines versus Polaris Bank, where the court held a successful plea of limitation of law as a shield by an opposing party, occasioned two harmful efforts against the claimant's action. First, the claimant become disrobbed of the right of action and judicial relief. In other words, it extinguishes his course of action. Second, the court ceases to be crowned with the requisite jurisdiction to entertain his action. See also in Inaduka versus Anunobi, where the court held that where an action is caught by statute of limitation, the court is deprived of jurisdiction to entertain same, as there would be no live dispute for the court to entertain and adjudicate over. End of quote. I hereby dismiss the claimant suit as constituted on the ground that it is caught up by Section 8 of the Limitation Law of Lagos State, and this court lacks the jurisdiction to entertain same. This is the judgment of the Honorable Court, and it is hereby entered as signed Honorable Justice.
As the court pleases.
Yes, any other case?
No, my lord, that's all, my lord.
Okay, thank you, counsel, for joining. We have come to the end of today's proceeding.
Thank you, my lord.
Thank you,
And
Thank you, my lord.